Hello and welcome to the Rodgers Brief. I'm Adam Rodgers. Thank you for watching and thank you for listening. Now, for those of you that have been following or watching the Rodgers Brief over the last number of months, you'll know that I usually cover the Mass Casualty Commission proceedings. Now those are now wrapped up and I've changed my format. And so now what I'm doing is going through 4, 5, 6 stories a week that either have a legal angle that's maybe underappreciated, or else it's just an important legal angle and I think would be of interest to you. So I'm going to do that from now on. I'll do once a week and release them on Sunday mornings, and so you'll have that to wake up to as you're reading your Sunday news and doing all that. So this week I'm going to be talking about 6 stories. The first one is I'm going to be covering the week that was in the Emergencies Act inquiry that's taking place in Ottawa, and there's been some news out of there this week. Second story is the Canadian Civil Liberties Association Court of Appeal victory in Nova Scotia this week, and that had to do with the protests, some protests of the vaccine mandates and the COVID restrictions that were supposed to take place in May of 2021, and there was an injunction that the province sought and gained. Well, that went to the Court of Appeal, and so I'll talk a little bit about that case and the implications. Third story I want to cover is COVID related as well. This one's out of British Columbia, but I think it'll have national implications. This was the first Superior Court decision that was in a non-union context of vaccine mandates that were mandatory vaccination policy that an employer had enacted. An employee refused to get vaccinated, and so there was fallout from that. So we'll talk about that case. The fourth story is local, but again with some national perhaps implications. The Dalhousie Law School has announced that they're going to be doing a mandatory course for first-year students on critical race theory, and so I'll discuss that briefly. Fifth story is Nova Scotia-based as well. This was a decision of the Supreme Court of Canada to do with a land use case, and this was the Blue Mountain Birch Cove Lake area where a private company owned the property. Halifax regional municipality rezoned the area into sort of a protected land, and so that became the allegation was that was now an expropriation case. Went to the Supreme Court of Canada, and the Annapolis Group was victorious in that case in the Supreme Court. So talk a little bit about that again, and then finally talk about a case out of the United States, but also how it's reflected in Canada, and that is the announcement from President Biden that he was going to issue pardons for anybody that had a federal record for simple possession of marijuana. So I'll look into that a little bit and compare that to the approach that the government of Canada has taken up here. But before I get to that, I'll just let people know that I'll be appearing tonight on the Nighttime podcast with Jordan Bonaparte. Very entertaining podcast. He's a great host, and so we'll be talking about the Mass Casualty Commission and my alternate or competing perhaps report on the final report, competing against the Commission's official version, which is going to come out at the end of March. Mine came out last week as an ebook. You can purchase it now on Apple Books, Kobo, Barnes & Noble, or Smashwords is where it's originally published. And so I'll link to that in the YouTube description of this video, and you can check that out. So getting good reviews on it so far, and be happy to talk to Jordan about that tonight. And I'll tweet out the time, and I'll put it up on Facebook as well as to what time that video is going to be taking place. Actually, once I get the time, I'll put it in the description of the YouTube video as well. Okay, so first story, and that is the Emergencies Act inquiry. And this week in Ottawa, we've heard more from the Ottawa police superintendents and superior officers about, and what we're learning is really that the Ottawa police really weren't all that prepared for the trucker convoy, even though they had received pretty significant intelligence from the Ontario Provincial Police that this convoy was going to be coming and they were going to settle in. One of the other things that came out this week was that some of the trucks left after the first weekend, but the Ottawa Police Service didn't shrink the protest area, make it more manageable. They had refused to negotiate with anybody connected with the truckers, and so things just persisted. We also heard this week from Ottawa Police Service Superintendent Bernier talking about how the Emergencies Act, in his view, wasn't needed. Now, we're hearing some back and forth on this now. At some points, officers will say that it wasn't needed. For example, Commissioner Brenda Luckie of the RCMP said, well, not all non-Emergency Act options had been exhausted, but hey, government, if you give me these powers under the Emergency Act, certainly they'll be used. But the big thing I thought had been significance of the Emergency Act was to compel these the tow truck drivers to come in and tow the trucks away. And of course, they wouldn't want to be associated with that and get the bad publicity and who knows what from the truckers that they may have feared. So, but what we're hearing now is that that had all been arranged before the Emergency Act, that there were stickers or magnets placed over the logos of the tow truck drivers so they wouldn't be targeted specifically from the protesters, and that there was like 38 tow trucks that had been commandeered or employed or put into service to help with the government's efforts or the police's efforts to fight the protests. Another issue that's coming up, the two other things. One is there's going to be some secret testimony coming up from CSIS officials about intelligence that they had gathered. Now, this is going to be, there's 3 hours of testimony that Justice Rouleau is going to hear. He doesn't say when he's going to hear it. He doesn't want people to see people coming in and out of the building, I guess, and who that might be even. And so there's going to be some limitations on that. After he hears the testimony, he'll decide how much of that can be made public thereafter. Not unusual for this, for an inquiry to hear this. Actually, I thought this might take place during the mass casualty inquiry, had it come out in some sort of more legitimate forum that Wortman had some connection to the police. It didn't happen there. It did happen in the Mehar Arar inquiry and in the Somalia inquiry. There was some national security issues, and so some of the testimony was heard in camera in secret. The other issue is Doug Ford, Premier Doug Ford. We're hearing some of his, allegations against Doug Ford, that he was, he was in hiding. He was trying to avoid being involved in the protests in any way whatsoever. Now, he said he stood shoulder to shoulder with the Prime Minister and all this. Well, so now he's been called to testify. He's been summoned by the inquiry. And Premier Ford and the Solicitor General, which would be the Justice Minister of Ontario at the time, Sylvia Jones, are both refusing to appear, and they are claiming parliamentary privilege. So, what is that? What does that mean, and does it have a chance? Well, yes, parliamentary privilege is what exempts either members of Parliament or members of provincial legislatures from testifying at civil proceedings, either during a session or 40 days prior and 40 days after that session is finished. So it takes away a good chunk of the year. Well, federally it does. Provincially, where, especially in Nova Scotia, the sittings aren't that long, it may not have the same kind of effect. Well, Ontario legislature is sitting currently, and so Doug Ford is saying he's not inclined to testify. Of course, he can go voluntarily if he wishes to do so, but this parliamentary privilege would enable him to avoid going, if he so chooses, to stick with that. Now, there's an interesting decision from 2003, interesting if you're into parliamentary privilege rules, I guess, from Speaker Peter Milliken, who was a highly respected Speaker in Parliament for many years, that it is Parliament itself, or the legislature, not the courts, that should make these decisions on parliamentary privilege. So what I think the outcome of this is going to be is that Doug Ford's claim, Doug Ford is going to court to, oppose this summons. What I think the proper procedure actually is, according to Speaker Peter Milliken, is that claim would be made in the legislature itself. The legislature would confirm it, and then the courts would have to respect it. The inquiry in this case, which has the powers of a civil court to compel testimony, to compel witnesses, to compel evidence, that they would have to respect that parliamentary privilege claim from Premier Ford and Minister Jones. But like I say, it's up to the legislature and not the courts to make that determination. Now, interesting little comparison, just if anybody's following news out of the United States, that the January 6th hearings in Congress, and that President Trump has refused to comply with a request, subpoena to appear before Congress. And that's interesting. Now, Congress in that case, it's a different story there. He's not a sitting president anymore. Some former presidents have been called and testified before Congress under different circumstances, usually negotiated. President Trump has absolutely refused. So Congress in that case has two options. They can either seek a federal court order to compel former President Trump to comply. That could take many months and would probably not going to work out. The second option is to find President Trump in contempt of Congress and then have the Department of Justice prosecute him, as they've done actually with Steve Bannon, a former advisor to President Trump, who just got sentenced to 4 months in jail. So although he's appealing that, and probably will successfully appeal that if I'm reading the situation correctly. So we'll see what happens down there. We'll see what happens with Premier Ford. Sounds like he's not going to testify, and the inquiry will have to be satisfied with provincial officials instead. Okay, so that's the Inquiry Act. A little more time on that than I had planned to spend, but an important situation going on nationally. Second one, this is also, I think, important, and maybe it'll harken, well, depends if there's another pandemic or if there's any other protests, pandemic-related protests, but the Canadian Civil Liberties Association had appealed an injunction that was laid down by Justice Norton last year. So there was to be these protests in May of 2021 on Citadel Hill, other places, I think in Halifax and in Barrington, strangely in some ways maybe. But so the Department of Justice and Public Health through Dr. Strang applied to the court for an ex parte, that means without notice to any other parties, order that would ban any such protests. And Justice Norton granted the order, and so that you weren't allowed to protest, and there would be civil consequences if anybody did. Now, the Court of Appeal took a very dim view of all this. In other words, they sided with the Canadian Civil Liberties Association, very critical of the Health Department, Public Health, Justice Department, and of the decision, I guess, of Justice Norton. First of all, said that the application should not have been ex parte, that they should have provided notice to these people, because some of them were protest organizers who were known entities. They had been communicating and following them on social media, could have let them know, could have just publicized, just to anybody that was interested, like the Civil Liberties Association, who would have certainly intervened, that this application was taking place. They didn't do that. The Court of Appeal was quite critical of them for not doing so. Well, the second point is, so that it shouldn't have been ex parte. Second point is that the Court of Appeal was entitled to hear it, even though the issue is now moot. The state of emergency is now over. But what the Court of Appeal says is this could happen again, and there's a principle there that needs to be established by the Court of Appeal in case, to guide any future efforts to have an ex parte order of this nature. The judge said, the Court of Appeal said, that the original judge should have considered the charter rights of people protesting, the right to free speech, the right to gather and assemble, free assembly. So that should have been considered. Really wasn't explicitly covered in the original court decision, and that the injunction was far too broad. Instead of just covering these narrow protests, specifically identified protests, the injunction covered the whole province. So nowhere in the province could you gather to protest against the imposition of COVID restrictions or restrictions on protesting. The other thing, it was too broad, and there was expert evidence. First of all, the court was critical that Dr. Strang himself, who was an applicant as the chief medical officer for public health, was also made and was also accepted as an expert witness. So to be the applicant and also an expert on the same case they were very, very critical of, the Court of Appeal was critical of that. And Also that these were outdoor protests and that his expertise or the expertise that was presented didn't establish that outdoor protests at that time, this was in May of 2021, that the transmission of the virus in outdoor settings was clearly established. So that wasn't, that was another reason to overturn the appeal. And that the Attorney General, if anybody's looking for an injunction against their neighbor, against a business, maybe you don't have to have a special obligation, but the Attorney General does have a special obligation to consider and bring evidence on the impact of an injunction on the charter rights of citizens. So that wasn't done and should have been. Now, what's going to happen now? I think this just provides guidance if there's any restrictions or protests in the future and how courts would handle injunction applications in those cases. I don't see why the government would appeal this decision to the Supreme Court of Canada. Rather, instead, they should just use this as guidance as to how better to handle things next time around. Okay, so that's the second story. That was the Canadian Civil Liberties Association challenge to the Nova Scotia protest injunction decision. Third story. I'll be brief on the next few stories. Will be brief. Third story is out of British Columbia, and this is a decision on mandatory COVID-19 vaccination policy in a non-union environment. Paramar versus Tribe Management. This was an office environment. The worker, Ms. Paramar, was an accounting professional, they say. 200 employees, and it imposed a mandatory vaccination policy. Ms. Paramar had suggested that she work from home, only come in to sign checks on certain occasions under conditions, get frequent tests. And the company said, no, we need you to do this or we're going to put you on unpaid leave. And so Ms. Paramar considered that to be constructive dismissal, in other words, to be fired without really being fired, and sought relief on that basis. Court said no, that was a reasonable policy, that the COVID-19 pandemic was an extraordinary context within which it was not unreasonable to enact such policies. So here we have our first Superior Court decision in the country dealing with a non-union context. So if you're out there and you're in a non-union context and your employer has had a vaccination policy, quite likely you would have had to comply with that in order to keep your job. All right, next story. Dalhousie Law School, my old law school, Sherlock Law School now, I guess it's called, has created a new course, sort of. This is a course where there's 3 days in October, 2 days in February, and the release from Dalhousie Law didn't really indicate whether there was an exam at the end of it or how it was going to be marked or graded or accredited to each student, but they all have to take it, first years. And it's on African Nova Scotia legal history, issues, history and issues, and critical race theory. Of course, critical race theory has become a hot button item in the United States. Less so here. I took a course, sort of. When I was in third year, I took a course called jurisprudence, which is essentially the philosophy of law. And in that, we did a class on critical race theory, really just looking at how racial elements, need to be examined. You deconstruct the law and see how it differentially affects people from different races. The easiest example is the street checks, things that police do. Well, if you say, well, you can check anybody that looks suspicious or anybody that looks like they might, be up to something, you can do a quick street check. Well, guess what? Who's going to be most impacted by that are racialized minorities. And so even though the law on its face seems to apply to everybody equally, in practice it applies discriminatingly. And so that's something you need to examine and try to deal with through other ways. So the course that has the objectives and understanding. Objectives are to understand the law's role in creating and redressing anti-black racism and other forms of discrimination. Understanding how critical race theory in practice can dismantle racial inequality, and how African Nova Scotians are a legally distinct people, which is true. There's certainly in criminal law for sentencing, you could have a cultural impact assessment done, and for African Nova Scotians, and that is they're very helpful. And for how to be culturally competent lawyers in the context of your professional responsibilities. And so this is this is good. Dalhousie has had a strong Indigenous Black Mi'kmaq program for many years now, and this is just a continuation or an ongoing development of that. Like I say, it used to be taught as part of jurisprudence. It probably still will be, and this is a nice addition to it, so keep an eye on that. I thought it would be interesting for people to study, or people to be aware of. So next story will be the Annapolis Group versus Halifax Regional Municipality decision. This went to the Supreme Court of Canada. Now, so the background is Annapolis Group owns lots of property, many acres around Blue Mountain, Birch Cove Lakes area, northwest of the city. They had been looking to, they'd owned it for many years, hadn't done much with it, but they were looking to develop it. Halifax then changed the zoning to urban settlement and urban reserve, so effectively prevented Annapolis from developing the property as they had in mind. So the question is that an expropriation? Well, Annapolis still owns the land. The government hasn't taken it from them. But, when this was first coming through, it seemed to me clear that it was an expropriation in kind, if not in name. And so what the Supreme Court of Canada says, well, they looked at it as a constructive taking. So in other words, even though you still own it, we, as the government, effectively control it and restrict everything that you can do on it. So it's effectively now taken, and an effective expropriation. So what happened, the history of this, so this wasn't, the Supreme Court of Canada didn't decide that yet. What this was, the city of Halifax had made an application for summary judgment to say, listen, this isn't even a case. There's no such thing as constructive taking. You can't even call this expropriation if we didn't take ownership of it. The case should be dismissed just on its face. So Annapolis opposed that. The Nova Scotia Supreme Court at the first level sided with the Annapolis Group. This isn't Annapolis Valley government. This is a private company. They sided with the Annapolis Group. Went to the Court of Appeal. The city of Halifax appealed that decision. So at the Supreme Court level, the first level, the city had applied to dismiss the claim on the basis that there was just no claim there. Supreme Court sided with Annapolis. Court of Appeal sided with the government, saying yes, this is this is not an expropriation, and they overturned it on appeal. Went to the Supreme Court, and now the Supreme Court restored the original motions judge decision that says land doesn't actually have to be taken in order to be called expropriation. If the regulation prevents you from using it the way you want to use it, that's the same thing. So now, that's not the end of the story. Now it can go to trial and figure out if indeed, based on those guidelines, this was an expropriation, and then what's the value that Annapolis has lost by not being able to use this property in the way they wish to do so. What's going to happen? It could go to trial. I wouldn't be surprised now that the Supreme Court of Canada has set these guidelines, which aren't really that difficult to follow. I suspect the parties will negotiate and settle that claim. So no doubt we'll be hearing more about that in the next few months. All right, so that's the Annapolis versus Halifax claim. Final situation is this U.S. marijuana pardon. Big news when it came out from President Biden. Lots of people thought it was wonderful news. So what happens is it was a pardon for some people with a simple possession record, but there's many caveats. First of all, it's only those who were convicted under federal law. Now, it's different in the United States. In Canada, there's the criminal law, which just applies across the country. There's not, there's no real separation of federal versus provincial. In the United States, it's a little different. In the United States, actually, there's 19 states which have which permit recreational marijuana, so 31 that don't, and federal law overlaying all of that, which still, where it was still illegal. In fact, marijuana is categorized in the same way as heroin, cocaine, and all those in the same drug schedule. So it's treated very harshly in some ways. So it doesn't apply to people who were convicted under state law, which is most people, or local laws. In fact, there's only about 6,500 people in the United States eligible for this pardon. Although, so it seemed like a big deal that President Biden was pardoning all these offenders. It's not clear that anybody was actually in jail for federal-only marijuana offenses. But it sent a signal, and now the next step will be for the United States to change marijuana from the same schedule as those harsher drugs into its own schedule, probably, and perhaps at some point decriminalize it or legalize it as we have in Canada. So you would think that Canada would have already done this since we have a different legal regime when it comes to cannabis. But what Canada has done is quite actually less than what the United States has done. In Canada, first of all, there's no real thing as a pardon. It's called a record suspension. So, you know, if you're applying for a job, it's helpful, but if the police are checking on you, it's still there on your record. So it's not quite a pardon as it is in the United States and as it used to be in Canada. Normally you need a 5 to 10 year time frame after you've been convicted before you can apply for a pardon in Canada. There is an expedited process now where you don't need to have that 5-year waiting period for a marijuana offense. But very little uptake on this so far. This is started in 2019 when the legislation came into effect. 10,000 people in Canada with marijuana alone records. Only 458 people have applied for a pardon under this, or record suspension, and only 257 of those have been granted. So just over half of them have been granted. Now there is a fee, a $631 fee normally if you're applying for a pardon. That's waived for these offenses. But still, very little uptake on that so far in Canada. Perhaps because it's a record suspension and not a pardon, so it doesn't have a real effect. And you need to apply. It's not something that's done automatically on the government side in Canada or the United States. Seems like something that would be much simpler to do that way rather than forcing people to apply, but that's the system. And I guess if people are interested in helping themselves, it's not a big deal to make an application. But anyway, we'll see. Okay, so that was something I thought you might find interesting out of the United States with some implications for Canada or some connection. So that was it. The Emergencies Act inquiry. Canadian Civil Liberties Association challenge to the Nova Scotia protest injunction, COVID-19 protest injunction. BC Supreme Court on mandatory COVID-19 vaccination policies in non-union environments. Dalhousie Law's mandatory course on African Nova Scotian legal studies and critical race theory. The Annapolis Group versus Halifax expropriation-ish decision. And the pardons for marijuana offenses. So thanks everybody for watching, and thanks for listening. I'll be back next week, and like I said, be sure to tune in if you're able to tonight and interested to hear more about my thoughts on the Mass Casualty Commission, my report that's available now on Apple Books, Smashwords, Kobo, Scribd, everywhere you look. So thanks again for watching, thanks for listening, and we'll see you next time.